Imagine you applied for a UK visa, waited for weeks or months, and then you receive an email saying your UK visa application has been refused. At that moment, most people panic. They don't know what to do next. Should they apply again? Should they appeal? Should they challenge the decision? Or is the case finished? The important thing to understand is a visa refusal is not always the end of the case. In many situations, you still have legal options. In this video, we will explain UK visa refusal, what to do, and what legal steps you can take after a refusal. Watch this video till the end because this information is very important for anyone dealing with UK immigration matters. Welcome to BritLaws, where we explain UK laws, legal rights, and legal awareness in simple and practical language so you can understand your rights and protect yourself legally. Today's topic is about UK visa refusal. Many people apply for visit visa, student visa, spouse visa, work visa, and settlement visa, and sometimes the application is refused. But after refusal, the most important thing is what you do next. When the UK Home Office refuses a visa application, they normally issue a refusal letter explaining the reasons for refusal. This letter is very important because it tells you why your visa was refused, whether you have the right of appeal, whether you can apply for administrative review, whether you can submit a fresh application. Not every visa refusal has the same legal remedy. Different visas have different options, such as appeal, administrative review, judicial review, fresh application. So the first step is always to carefully read and understand the refusal letter. If your UK visa is refused, you may have one of the following rights, depending on your case. 1. Right of appeal. This usually applies in cases like spouse visa, human rights applications, asylum cases, and some settlement cases. You can appeal to the Immigration Tribunal. 2. Administrative review. This applies mostly to student visas, work visas, and points-based system visas. Administrative review means you are asking the Home Office to review the decision because you believe a caseworker made a mistake. 3. Fresh application. In many visit visa refusals, there is no appeal right. The usual option is to apply again with stronger documents and explanation. 4. Judicial review. In some cases where the decision is unlawful or unreasonable, the decision can be challenged in higher courts through judicial review. Let's take a practical example. Suppose someone applies for a UK visit visa and the visa is refused because the Home Office is not satisfied that the applicant will return to their home country. In this situation, the person should carefully read the refusal reasons, identify what documents were missing, provide stronger financial documents, provide employment letter or business proof, provide travel history if available, write a proper cover letter addressing refusal reasons, then apply again. Another example. If a spouse visa is refused, the applicant may have the right of appeal, and the case can be challenged in the Immigration Tribunal. So the action depends on the type of visa and refusal reason. Now, an important question. What if you believe the visa refusal decision is wrong or unfair? In that situation, do not immediately reapply without understanding the refusal. Carefully read the refusal letter, check whether you have appeal rights, check administrative review option, collect supporting documents, and seek immigration advice if necessary. Many people make the mistake of applying again without addressing refusal reasons, and their visa gets refused again. So the correct approach is understand refusal, fix problems, then take legal step or reapply. If your UK visa is refused, the general legal process may be as follows. Step 1. Read refusal letter carefully. Understand the exact reasons for refusal. Step 2. Identify your legal option. Check whether you have appeal, administrative review, fresh application, judicial review. Step 3. Prepare stronger documentation to address refusal reasons. Step 4. Immigration cases have strict time limits, so delays can be dangerous. Step 5. Whether appeal or new application, you must address the refusal reasons clearly. Remember, most successful immigration cases succeed because refusal reasons are properly addressed. So today we learned a UK visa refusal is not always the end of the case. Always read the refusal letter carefully. Some cases have appeal rights, some cases have administrative review, some cases require fresh application. Judicial review is possible in certain cases. Never reapply without addressing refusal reasons. Always act within time limits. Understanding the correct legal step after visa refusal is very important in UK immigration matters. If your UK visa is refused, do not panic and do not immediately submit a new application without understanding the refusal reasons. Stay calm, read the refusal letter carefully, identify your legal options, collect proper documents, and follow the correct legal process. In UK immigration law, many refusals are successfully challenged or approved later when the case is properly prepared and legally presented. If you want to learn more about UK laws, immigration laws, visa rules, employee rights, tenant rights, and legal awareness, please subscribe BritLaws. Join us in the next video as we discuss about self-defense law in the UK. See you in the next video.